Yes, I'll start.
Good afternoon, all. Today we have an urgent ex parte application hearing before His Excellency Justice Omar Al Muhairi in the matter of CFI-022-2018. The claimant is represented by Al Nuaimi and Company. The lead counsel is Rupert Reed QC, assisted by Peter Smith.
Robert, right?
Rupert. This is, as your associate said, an urgent application of interim injunction to prevent the sponsor of a school in Ajman from continuing a campaign that has been intended to destroy the business of the school. The school is owned by a company, Avalon Heights, that's the third claimant in the action. In turn of that company, there is a majority shareholder, Sheikh Khaled, as I'll refer to, who is the 51% majority shareholder, but he holds those shares importantly as the nominee for a minority shareholder, which is Avalon Global, the second claimant. And that company is in turn owned by Mr. Sharma, the first claimant, and his daughter. Sheikh Khaled has been doing everything he can to damage the business of Avalon Heights, the third claimant. We identify in the skeleton and in the affidavit of Mr. Sharma 5 instances of things he has done which are extremely damaging to the business. The first I'll refer to as the encashing of a cheque, which was a cheque which had been replaced as a security for a loan from the Ajman Bank. And the encashing, or the attempt to encash that cheque, has had the result that Mr. Sharma is now subject to a travel ban and is unable to attend before the court for that reason. The second instance is Sheikh Khaled attending either himself or through members of his staff at the site in order to intimidate, we say, staff at the school. The third instance is the false statements that he has made regarding the operations and ownership of the school. The fourth is the revocation of a power of attorney, which he was required to give under the side agreement, which he did give, and which he then revoked in a notarized notification. That has had the result that the facility of the school with First Gulf Bank has effectively been frozen. So the school is unable to be administered financially with that account being frozen. The fifth instance is various false statements made in a letter to another bank, Asil, the Abu Dhabi bank.
Asil or Asail?
Asil.
Asil?
Yes, it is Asil. And that again, that account has effectively been frozen as a result of a letter written, which we refer to as the 1st of March letter. And what the claimants, all 3 of them, seek is an injunction to require Sheikh Khaled to desist. Because if he doesn't desist, and if he doesn't desist immediately, given that many of the actions that are complained of happened last week, there's been an intensification of the campaign against the claimants. If he doesn't desist, then the school and its business in Ajman will be destroyed. And we don't shrink from that allegation. In terms of housekeeping, your Lordship should have in the hearing Bible a claim form, which I think was issued last night, this morning.
It's before me.
Also an application notice.
Which is, I have a question on this.
Okay. And also a draft order. If your Lordship does have a question, it may be worth dealing with that straight away.
Yeah, actually, why is it without notice?
Why is it without notice? Well, the fear is that if Sheikh Khaled is put on notice that, for example, we are seeking these orders against him, he may seek to intensify the campaign even further. He may go to political authorities or political bodies in Ajman and seek to cause difficulty for the claimants. So the feeling is that if an order is obtained to restrain his behaviour, then that, and you'll see the terms of the order sought in terms of, for example, making notifications to public authorities, that will prevent him from continuing what he's already doing in terms of trying to cause trouble for the claimants. For example, by making false representations to public authorities in the Emirate of Ajman.
So he appeared that he's an owner of the school or something else?
Well, exactly. The allegations he's made are either about his ownership, so he says, I'm the owner of the school and therefore I have power and authority to do things. So he makes those sort of representations. He also makes representations about the conduct of staff, about the administration of the school. And we can see from the representations he's made to date that he's not slow to make very damaging allegations on we would say, no evidence, with no investigation, and no attempt at any due process in terms of the investigation that he should have taken before making what are very serious allegations. So our concern is that if we tip him off, if we give him warning that he's going to have, that we are going to court, he might seek to do something completely irreversible or irremediable, which couldn't be remedied before we got to the court and sought the protection of the court by way of an order of the court.
Okay.
So that's the clear and present danger as we perceive it.
Fine. And what about the jurisdiction?
Jurisdiction, well, you'll see hopefully the
Yeah,
section.
I saw your point in jurisdiction, but I have one question. Maybe you help me on this. If you go back to the memorandum of establishment of which dated the memorandum of association.
Yes.
Dated 26th of May 2015.
Can you remind me where that is in the hearing, by which page that is in the hearing?
Actually, on page 13, tab 6.
Yes, thank you. Yes, thank you.
I make it short for you because it's
Yes.
clear for me. I have time already. I saw the whole documents. I read it, most of 90% document.
Right.
So I have some slightly question, need answer. Why you bring this case before this court?
Well, we bring this case before this court for...
Because when I looked to the jurisdiction, it seems to me the general rules related to the Ajman court, because the memorandum of association based on the civil procedure law and company law, which refer to the domicile of the defendant.
Yes, so one has the UAE company law, to the extent that that applies in respect of the memorandum of association, that applies. But what the parties have done in terms of their own submission to the jurisdiction is they have entered into a number of agreements, private agreements. Now, the first of those is the collaboration agreement, which comes before the memorandum of association.
Which is starting from the
That starts
37.
That starts from page 1. That has a express provision in respect of DIFC, first of all, DIFC law and jurisdiction.
Which is governing law, Article 12.
Which is a page 2, isn't it? So that's clause 6. Now the collaboration agreement has been substantially superseded, replaced. But if one looks at clause 6, applicable law and jurisdiction, any dispute arising out of in connection with this agreement, including any question regarding its existence, validity or termination, should be subject to the exclusive jurisdiction of the courts of the DIFC, so exclusive jurisdiction. And this agreement shall be governed by and construed in accordance with the laws of the DIFC. Now, if one had a dispute...
Pause here. Just you can help me on this as well.
Yes.
If you go back to the previous, the memorandum of association, Article 16, and will be page 22 of the tab 6. Article 16, variation of this memorandum.
So it shall not be permissible to amend this memorandum, nor to increase or reduce the capital of the company, unless it's approved by a number of partners holding 3/4 of the capital of the company, nor shall it be permissible to increase the obligations of partners save by their unanimous consent. Well, those are internal provisions relating to the relationships between partners.
Which is not against this memorandum?
No, in our submission, you can...
Because, as you know, the company is law says, and especially an LLC company, 51
Yes.
for UAE Emirati national and 49 for non-UAE.
Yes.
So if we go back to the, I can say, amendment of this memorandum,
Yes.
is demolish this
Well, there
principle.
are certain core rights and obligations which exist in the memorandum, which have force under UAE company law. Now, I can well see that, and capital,
and even so, not registered with the economical department and with the
yes, exactly. So that's registered, and that has
and
the requirements are that those rights and obligations should not be varied, save in writing, and no doubt there's a requirement of registration too in terms of amendment to the memorandum. So that's in a company in the UK, for example, one would have the memorandum and the articles of association, and the articles provide certain core rights. For example, in terms of calling a meeting, or in terms of voting on dividend, or the notice required for a meeting. Now, those are, if you like, the statutes. In many jurisdictions, that are called the regulations or the bylaws of the company. Now, on top of those bylaws, if you like, of the company, you also often have a shareholders' agreement, which lays out various rights and obligations, which are supplementary or build on or additional to the core bylaws, the core rights and obligations as they exist under the legislation, the statute, if you like, of the company, which is its memorandum and its articles.
But if this court, let's say, if we have a good arguable case, and which law will be applying here?
Well,
UAE commercial, UAE company law, or
if we are relying on rights and obligations that arise as a matter of Ajman or of UAE company law, and/or under the memorandum, then prima facie that would be a matter of Ajman law. But we're not. We're dealing with very clear breaches, we say, of the first of all the side agreement, which is again expressly DIFC law and the exclusive jurisdiction of the DIFC courts, and secondly the shareholders agreement, which again DIFC is subject to DIFC law and subject to the exclusive jurisdiction of the DIFC courts. So we're being very focused here, laser-like, in looking at particular breaches or particular obligations that arise. And I would propose to take your lordship to those obligations in terms of, for example, interference in the management of the company. And there is nothing, we say, that prevents parties to a shareholders' agreement that is subject to DIFC law and subject to the jurisdiction, exclusive jurisdiction of the DIFC court, from agreeing on those terms how they will conduct the administration of the company in any jurisdiction. And that's why we say there's no interference with the jurisdiction of the Ajman courts, or indeed no application of Ajman law required in the interpretation and the application of agreements that are subject to DIFC law.
okay, go ahead.
Now, well, my lord, I mentioned this is an urgent.
Sorry to disturb you, and you start wherever you want to start.
I'm grateful.
When I have a question, I pause.
That's the best idea. What I don't want you to do is have a question and me to be prattling on
Okay.
while you're worrying about another point or thinking about another point. Most of the damaging behaviour we have seen occurred last week, we would say, in a sustained campaign. As far as I understand the weekend, there are still staff at the school who are in detention in Ajman. I think 2, the number. We say that what this company, what this school need is an injunction. Now, any injunction your lordship makes will apply until the return date, and we are required under the RDC to provide for a return date in 3 days' time. So, in a way, the scope of today's discussion is about what happens for the next 3 days, or for some longer period, if the defendant wants to extend the period. So it's of relatively limited application, but our client still feels it's necessary to have that protection for the next 3 days. I've mentioned the jurisdiction issues, and I will take you to the relevant jurisdiction clauses, exclusive jurisdiction clauses. Your lordship is no doubt aware of the provisions in the court law which allow your lordship to make an injunction, and indeed to make an interim injunction. It's possibly worth looking at those for a reason which I will make clear.
Part 25?
Yes. If we could start with the court law, which I think is behind tab 1 in the authorities document. If I could take your lordship to page 22 in that bundle. Sorry, to article 22 in that bundle.
Yeah, it's working.
So just reading 22.2, the Court of First Instance may order an injunction, so your Lordship has a discretion to make an injunction, restraining a person from engaging in conduct, or requiring a person to do an act or thing or other order the Court thinks appropriate. Now, the first point I'd wish to make, my Lord, is that there's no distinction under DIFC law between a negative injunction and a positive injunction. The discretion which the Court has is equal. There's no difference. We would say, I should add, that what we're essentially asking for is a negative injunction, because factually we are asking for Sheikh Khaled to desist from the campaign that he's undertaken. But that may require, for example, him to reinstate a power of attorney. But whilst we're in the court, or if we could turn quickly to Article 32B.
But the power of attorney, already he's sent a letter to Ajman court to deactivate and other saying, or...
Yes, as far as we know, he hasn't actually yet done it. He's indicated that he may or that he will do it.
But he sent a notice to your client.
I'm unaware that we've received as yet a notice.
Yeah, actually, in the paper there's a notice. Send it.
We've received a notice. A new notice of a... It's a new power of attorney.
Yeah, we've received a notice that he
Yeah, sorry, he's notified us he's revoked it. What we may need... Sorry, I'm being stupid.
So then you have 15 days to challenge that notice.
Yes.
Based on the
Yes.
civil procedure law.
Yes.
Another say.
Well, I'll come back to...
I don't know how...
I'm jumping around and I apologise.
In case if I'm... let's say I'm issuing the interim order and seeking, or you're seeking, or to stay that notice, or asking Sheikh Khaled to stay any procedure to, let's say, discharge Mr. Or your client from be acting as an... how are you going to enforce it before Ajman court?
Well, I'll come on to that, because we say there may be issues under Ajman law as to, with respect to the notification and rights to challenge under Ajman law, but we say, as a matter of contract, there is a contractual promise on his part to provide the promise. If he is in breach of that promise, and that promise is subject to DIFC law, the DIFC court can order him to make good his breach. That's a fundamental power of a court dealing with a contractual claim, is to order someone not to breach a contract. And in that circumstance, we say this court is perfectly entitled to order him to make
But
good.
already he started the procedure.
He started a procedure.
Yes, by sending a notification. And I believe one of your colleagues is aware of, she's aware
Yes.
of that
Well, I
procedure.
think we are aware that he's sought to revoke, and essentially there's a notarized notice that he is revoking.
Anyway, continue.
Anyway, those behind me will. He has to vote. I'm waiting to vote, but the suggestion is that some procedure. Good. So I was taking your lordship to Article 32B in the court law. And again, GFC court has power to make orders, give directions of conduct proceedings for GFC court considers appropriate, including B, injunctions, including requiring an act to be done. So again, no issue with making a positive injunction. And then very quickly behind tab 2 in the bundle, we have the power to make interim remedies, and that's in the law of damages and remedies. If your lordship could look very quickly at Article 36.
Which article?
Article 36.
Yes.
So this court may grant the following interim remedies: A, an interim injunction, and then turning over page to Article 38. The court may, by order, grant an injunction in all cases in which it appears to the court to be just and convenient to do so, including such order as shall, and then A, restrain, and B, compel. So both negative injunction and or a positive injunction. And again, the test for your lordship, the test for the court is whether it appears to the court to be just and convenient. So the issue of justice in terms of preventing a continuing breach of a contractual promise. And I set out in my skeleton the relevant procedural rules. I think we can agree that the return date is should be not more than 3 days from the date of an order, and that there is required to be a cross undertaking.
And it depends on available judge to hear the case on return date.
Well, the return date would be Thursday, wouldn't it? I mean, ideally it's the same judge, because they've heard and they've considered all
But I have
the...
other application to deal with.
Well, in that case, one would have two alternatives. Either it could be on Wednesday, I would take instructions, or it could go in front of a different...
This point is earlier, we can discuss later.
Yes.
And you will get a notification from the registry, definitely.
In terms of the tests that the court applies substantively, first of all, the court has to consider whether there's a serious question to be tried. And that really is a threshold test. It's just, in essence, is the case that's being advanced by the claimant, is it arguable? Is it a serious question that should go to trial? And we say the arguments, the evidence for a breach of contract far exceeds that threshold. We say there is compelling evidence of breaches of contractual promises by Sheikh Khaled. The second part of the test is the balance of convenience. So if the court makes an order and shouldn't have, what damage is done to the defendant? If, on the other hand, it doesn't make an order, and it's found later that it should have made an order, what damage is done to the claimant? And we say that on that, it's clear that the balance of convenience strongly lies in favour of the claimant, because if the defendant isn't stopped, if Sheikh Khaled isn't stopped in what he's doing, then this school could be destroyed. The school that my client, Mr. Sharma, has spent the last 3 or 4 years building in Ajman, developing its business, and that could be destroyed, we say, in a matter of days. And that too feeds into the third element of the test, the third limb, which is whether damages would be an adequate remedy. And we say clearly not, because of the entirely destructive effect of the behaviour of the defendant. I would like now, if I can, to look at the underlying agreements. Your Lordship has the collaboration agreement at page 1 and following. So looking at the first recital, various investors, along with Mr. Sharma, intend to set up a K-13 British curriculum come IB school for boys and girls in the Emirate of Ajman. And then over page 2, the purpose, so the collaborative agreement is a definitive statement of intent. And then picking up Article 3, the second paragraph, this agreement shall be superseded if and to the extent that both parties enter into a specific agreement pertaining to the project, and so subsequent projects that would specify the details and modes of execution on each such project. And that is, we say, what has in effect happened. This agreement has been superseded by both the side agreement and the shareholder agreement, but it's still relevant insofar as it shows the clear submission of the parties to DIFC court jurisdiction and their choice of DIFC law. And one sees that, as I've mentioned, at the bottom of the page in Article 6. And then I think it's worth looking briefly at Schedule 1. So the sponsor, that's Sheikh Khaled, confirms at Article 3, and then looking at B, halfway down the page, on or before 25th January 2015, he will acquire the 3 adjacent contiguous plots. And then C, on or before 31st December 2016, he will ensure completion of the construction of building number 2, building number 3 on the adjacent plots with a total capacity for 2,000 students. And then D, the ongoing maintenance of the existing and the new buildings, as well as structural alterations, will be undertaken by the sponsor on an as-required basis. Just pausing there, there are a number of these obligations in respect of acquiring other plots, in respect of works on the other plots, that are dealt with in the lease. And the lease is a document to which I won't refer very substantially, other than the expectation of quiet enjoyment that the tenant should enjoy in the land. And the reason is that the parties, on one analysis, appear to have given thought to issues of proper law, to issues of jurisdiction. So the lease, which is about real estate, which is about property, is subject to Ajman law. But all of the contractual arrangements between the pure in personam, personal contractual relations, are governed by DIFC law, subject to the exclusive jurisdiction of the DIFC courts. And then, turning over to page 6 in the collaboration agreement, There is a schedule there of the rent that is to be paid quarterly in advance. And then I think I can go straight on to page 8. And there one sees the 51% shares to be held in the personal name of the sponsor, so the idea of nomineeship, that they should be in the name of the sponsor. The investors, so that's the claimant essentially, will arrange for the funding requirements of the school. The investors, that's to say the claimants, will nominate the members of the board of directors and provision in respect of the Articles of Association. And then 17, the sponsor agrees to irrevocably waive his rights to any share in the profits. So again, a contractual waiver of provisions that he would otherwise have to share in profit. So clearly the sponsor, Sheikh Khaled, believes that you have certain rights that exist or may exist as a matter of Ajman law in respect of majority shareholding, in respect of the entitlement to profits as a shareholder. But his belief, and he proceeds on the assumption, that you can waive those rights. You can waive his rights to a share in profits, and that his holding of the shares will be in his name. And what one then sees is in the side agreement, as I understand is common, and your Lordship will have great familiarity with this situation, is that under the side agreement he holds those shares as a nominee for the minority shareholder. Now, and I should say then, if one looks at Article 21-22, the sponsor has various, 21, the sponsor shall issue a power of attorney, so there one has the contractual promise to issue a power of attorney. Article 22, the sponsor undertakes to obtain licenses and approvals. And then over page 9, Article 23, at the top, the sponsor undertakes to procure for the school at his cost all the utility connections, including electricity, water, sewerage, gas, and telecommunications for each building, and then various other requirements. And I should say, Article 27, investors, so that's the claimants, shall arrange all of the finance for the school, whether by way of equity or debt, and shall be fully responsible for the fiscal management of School Co, which is Avalon Heights. Accordingly, investors shall have full and exclusive signature authority over all of the bank accounts of School Co, that's Avalon Heights. So that's the initial, very early agreement which the parties made on the 20th of December back in 2014. In mid-2015, a few months before the opening of the school, the parties then set out the real bargain between them, if you like, which is, first of all, the side agreement, and secondly, the shareholder agreement. And if one starts at page 37 of the bundle with the side agreement, it's an agreement between Avalon Global, so that's the minority shareholder, and Sheikh Khaled, who obviously is nominally, at least, the majority shareholder. And then if one goes over page 38, Article 3, or Clause 3, in order to satisfy the requirements of UAE laws, according to which 51% of the shares of a limited liability company incorporated in UAE have to be held in the name of an individual who is a UAE national, the beneficial owner has agreed to appoint the sponsor as trustee to hold 51% of the shares in the company, the trust shares. So you have an assumption of the application of UAE law, and then you have contractual provisions which overlay, they lie over the top of the obligations of UAE law. And then at 4, the parties desire to enter into this agreement to record their respective rights and obligations between them pertaining to the company, the financing, operation, management of the company, and certain other rights and obligations in relation to the company and their respective ownership interests therein. So a statement of intent that their rights, both parties were agreeing that their rights should be pertaining to the company, the financing and the operation, and its management should be under this agreement, that's to say the shareholder agreement. And the real declaration of trust, if I can call it, comes in Clause 2, appointment of sponsor. The beneficial owner, as beneficial owner of the trust shares, hereby appoints the sponsor as trustee to hold the trust shares in trust for the beneficial owner. 2.2, the sponsor hereby declares that it will, in effect from the day of this agreement, hold in trust for the beneficial owner on the terms set out below the trust shares and all interest, dividends, other accruals or distributions of profit or surplus or other assets in respect thereof, and all rights arising out of or in connection with the trust shares. Now, clearly the DIFC has a trust law. A trust is something that the DIFC court recognises. The fact that property, in this case shares, can be held by one person on trust for another person, such that the beneficial owner of the shares can essentially ask or instruct the trustee to act in accordance with the wishes of the beneficial owner, where there is a bare trust, as it's
But
called.
do you think not conflict with the company, UAE company law?
Well, I can see actually that there is an issue under UAE law about whether there's a conflict between side agreements which declare nomineeship in respect of majority shareholdings held by a local partner in a UAE company. My Lord, I am not a UAE lawyer. I do not pretend to be a UAE lawyer, but I do understand that there is a very complex issue in UAE law as to the validity of side agreements and whether they are or are not held to conflict.
Because there is a requirement by company law, you have to register
Yes.
the memorandum of association, even so if you amend it later.
Yes, and I entirely understand that, but one has the same in English law, that one has a requirement that the legal owner, so the trustee of shares, is the registered shareholder because they own the legal title to the shares. But that doesn't dictate what the position is in terms of the beneficial ownership of the shares. That, as I understand it, is very much, as I say, a live issue of UAE law, and I've seen learned articles discussing the conflicting cases in the UAE courts as to what the effect of those sorts of provisions, those trustee provisions is, and whether you can in fact have a nomination. And my understanding is that there are, and I'm not in a position to advance arguments certainly before your Lordship, who is a UAE lawyer, as to what the answer to that debate is. My understanding is that there are decisions going in each direction. And pursuant to those decisions, my understanding is that there is a practice that is not uncommon. In fact, in many companies in the UAE, one finds a local partner who is the majority shareholder with 51%, but who is subject to a side agreement by which he agrees that he holds those shares on trust. And clearly, there are then ordinarily provisions, because the sponsor or the local partner, the 51% majority shareholder, will have various controls, or there may be decisions that he may take, decisions that he may not take. And that is precisely what we see in this case. We see a shareholders' agreement which gives him certain rights, gives him a right to part of the revenue, to a share in the revenue, but at the same time it excludes him by his agreement from certain matters, for example, the administration of the company, the financial administration of the company, and circumscribes those rights that he would otherwise have as a 51% majority shareholder. I should premise that by saying that actually even a 99% shareholder doesn't have any rights in a company. Their rights are limited to being notified of a meeting, attending a general meeting, voting at a general meeting. But they don't have any rights to manage the company by virtue of being a majority shareholder. That is fundamental to the separation that exists between a shareholder on one part and a company. That is why a company is a different person in law from a shareholder, because the shareholder can't do anything as shareholder other than attend a meeting and a vote at a meeting. It's the general meeting which decides what the company does, but that's an action by the company, it's not an action by the shareholder. So, whichever view one takes of those UAE authorities and those UAE decisions in the different emirates about how one interprets the UAE commercial companies law and whether it allows these side agreements, the reality is, even as a majority shareholder, he can't do these things. And as a shareholder, he's entitled to make contractual promises as to how he will or won't exercise his rights, such rights as may exist under UAE law. So we say that's a fundamental distinction, if you like, between the requirements of statute and the requirements of UAE company law on the one hand, and the promises that are made by a shareholder, not as the company, as a shareholder, in terms of how the shareholder will or will not execute or exercise, I should say, the rights that they have as a shareholder. As I say, that's my understanding as to the position that exists under UAE law. So I was taking your Lordship through the collaboration agreement, and I think we got to the side agreement. And we've looked at the declaration of trust in clause 2. And then we need to look at clause 2.4 at page 42. The sponsor shall, from the date of this agreement, from time to time, as beneficial owner may require or request, in respect to the trust shares, execute a power of attorney in favour of the beneficial owner. So there's the contractual promise to execute the power of attorney in such form as the beneficial owner may require. Then I think if I can go straight on to clause 6 of the side agreement, which is set out in my skeleton, 6.1, all of the managerial and operational affairs of the company shall be entrusted to the beneficial owner, whose appointment shall be for an unlimited period of time. And then 6.2 is very important for our purposes. The sponsor shall, under no circumstances, hold any executive office in the company or interfere with the management and or running of the company, and shall at no time make any claim against the beneficial owner for mismanagement of any of the company, and hereby waive and abandon any such claims. Sponsor shall, upon the request of the beneficial owner, sign any and all minutes, resolutions or documents which may require his signature. The sponsor shall have no power to bind, contract on behalf of or manage the company in any way or manner. And then over 6.3, the sponsor shall, and only upon being requested by the beneficial owner, sign such documents as may from time to time be necessary or desirable in each case to enable the company to attend to all matters pertaining to government departments, agencies and institutions. Then if we turn on to page 49, looking at 6.5, clause 6.5, to the extent permissible by the laws, the beneficial owner shall have exclusive powers to perform, amongst others, the below, including but not limited to the powers provided in the MOA exercisable by the General Manager. So again, a reference to powers that exist as a matter of UA law under the MOA, the Memorandum of Association, and making those powers exclusive to the beneficial owner. So A, to conduct the day-to-day management of the company and execute and terminate all commercial contracts on behalf of the company. So that's exclusively a power of Avalon Global. B, to represent the company in all business matters required or necessary. And then if I could go to C, little 1, open, operate and close bank accounts on behalf of the company, borrow, lend, withdraw by check, transfer or other means. And then little Roman 3 at the bottom of the page, 49.
Do you think, sorry to pause,
of course.
Do you think the bank will accept this memorandum to open or to run the accounts? Definitely no.
Well,
And the bank will ask for the memorandum of association which registered with the economical department and commercial chamber of Ajman.
well, to some extent that's true. I mean, that is the experience, is that any issue as the authority, even when it's just a shareholder, when a shareholder is saying, I'm not happy with this, the banks take a very risk-averse, they're very frightened of any risk. And so if there's any hint of any dissension, any argument between shareholders, the experience is the bank then just freezes everything. And we say that's why the power of attorney is necessary. Now, we say it should not be necessary. It should not be possible for one shareholder to say, well, I'm worried about this, I have a problem, I don't want the accounts frozen. But your Lordship is entirely right. That is the political, factual reality, and that's why we need the power of attorney. That's why we need these companies need the protection of this court. And my Lord, I'm instructed by those behind me who know more about UAE company law than I do of two things. Firstly, there is no conflict between anything we are asking for and the MOA, the Memorandum of Association. Indeed, if one looks at the Memorandum of Association, one sees that Mr. Sharma is the first claimant, is the general manager. So even under the memorandum, the powers of the company, and the administration and the management of the company are reserved to Mr. Sharma. And I should say too that there is nothing in the orders we're seeking which contravenes the UAE Companies Law, subject to the wrinkle about the extent to which a nomination is consistent with UAE law, which is very much a live question, and a question on which there are authorities on both sides of the argument. So it's just a brief point we wanted to make strongly in respect of the Memorandum of Association. We are not flying in the face of the Memorandum of Association. We are not arguing, we are not accepting that there's a conflict between the contractual rights. The contractual rights essentially build on the position in the Memorandum and the position as it exists under the UAE Company Law. So we've looked at 6.5 of the side agreement, and I think if I could just... So, yes, at the bottom of page 49, 1, to open bank accounts, 2, to borrow, lend, withdraw money, 3, obtain credit facilities, and then over page 50, little Roman 5, in general undertake any financial transaction. So this is the majority shareholder saying that it will not interfere in any way, or in general undertake any financial transaction. D, to commence or defend. This is 5. This is what the minority shareholder is entitled to do: to commence or defend any actions or legal proceedings which the company is or may hereafter be interested or concerned in the UAE courts. So again, Avalon Global has an express power agreed by both parties to commence proceedings on behalf of the company, let's say Avalon Heights. And then if I could go on all the way to page 57, we have clause 11 at the bottom of the page, miscellaneous. And then if I could take the court over page to the bottom of page 58, 11.4, each of the parties undertakes to do all things reasonably within his power, which are necessary or desirable to give effect to the spirit and intent of this agreement and the partnership agreement, and to act at all times with good faith towards the other party. So 2 obligations there in the same clause. First of all, an obligation to act in accordance with the spirit of the agreement. And the spirit of the agreement, we say, is about Mr. Sharma being entitled to run the company, and about Sheikh Khaled not being and not getting involved in the running and the management of the company. But also, with that, an obligation to act at all times with good faith towards the claimants, the other parties, or the minority shareholder. And then if I turn on to page 61, well, that's the governing law and dispute resolution procedure, but worth reading. Governing law, clause 12, is the laws of the DIFC, and clause 13, dispute resolution. Bottom of the page, the parties shall endeavour to reach an amicable settlement of the same through mutual consultation and in good faith as promptly as possible. 13.2, if the parties are unable to resolve a dispute through amicable settlement, then the dispute shall be subject to the exclusive jurisdiction of the courts of the DIFC. So that's, as we've said, it's not. I mean, one commonly sees in these sort of agreements non-exclusive jurisdiction clauses where the parties want to allow each other to come to the DIFC courts. The intention of this is to exclude the parties going to any other court. So the parties have sat down and said, we want to agree that Mr. Sharma can't go to the Indian courts and that Sheikh Khaled can't go to the Ajman courts. We agree that the proper courts to decide these contractual issues as a matter of modern international commercial law should be the courts of the DIFC, and that's their choice made in all of these agreements.
An opt-in.
Sorry?
An opt-in.
It's an opt-in, exactly. But it's an opt-in. I mean, an opt-in just means we say that the DIFC court should have jurisdiction. That doesn't, by itself, stop one going to the Ajman courts, unless they say you can only go. It's an exclusive opt-in. You can only go to the DFC court. So it's a particular form of opt-in which is exclusive in terms of preventing the parties from going to any other jurisdiction. And obviously that is emphatic in terms of the opting in. And then we have at page 63 the shareholders' agreement. Now, as I said, in virtually in every commercial jurisdiction, the shareholders have rights under the bylaws of the company. They are entitled to agree amongst themselves how they will and will not execute those rights. And that's what the shareholder agreement does. It sits on top of the bylaws, the articles and the memorandum. But it is nonetheless enforceable. as a matter of contract between the parties. And sometimes one sees it not only binding the parties, the shareholders, but also binding the company itself. So sometimes it's even more intrusive. This is a less intrusive form of shareholder agreement because it doesn't seek to bind the company itself, it only binds the shareholders. So the agreement is between Avalon Global and between Sheikh Khaled. And one sees there in the recitals at the bottom of the page, setting up a school, and then reference to Avalon Heights, and the shareholdings in Avalon Heights. And then if I can take your Lordship quickly onto page 67. And again, one has very similar provisions. So 2.2, the shareholders agree and undertake to exercise all voting rights and other powers of control available to them in relation to the school co, as to procure that at all times during the terms of the agreement, the provision concerning the structure and organisation of the school co and the regulation of its affairs set out in this agreement are duly observed and given full force and effect, and all actions required to the shareholders under this agreement are carried out in a timely manner. So you have to do things in a timely way. It's not good enough that you, at some point, you execute a power of attorney. You have to get on with it in a timely manner. And over page share capital, so at 3.1, top of page 68, the sponsor, Sheikh Khaled, acknowledges and confirms that he has not contributed in any manner to the share capital of the school co, and under no circumstances whatsoever to be entitled to any profits. And then 3.2, the parties acknowledge that 100% of the profits and losses of school co shall be to the account of holdco. So that's Avalon Global. And then, most importantly, from our perspective, at Clause 5, we have management. All of the managerial and operational affairs of the school company shall be entrusted to holdco, whose appointment shall be for an unlimited period of time. And then 5.2, the sponsor shall, under no circumstances, so this provision we see in both agreements, and in both agreements it's in very strong terms, under no circumstances hold any executive office in school co, or interfere with the management and running of the school co or the school, and shall at no time make any claim against holdco for mismanagement of the school co or the school, and thereby waive and abandon any such claims. The sponsor shall have no power to bind, contract on behalf of, or manage the school in any way or manner. Again, very emphatic language. There's no possible argument of interpretation or construction that somehow what the Sheikh has done, Sheikh Khaled has done, is consistent with his promise in 5.2 not in any circumstances to interfere. And then picking up at 5.5 over on page 70, holdco shall have exclusive powers to perform, amongst others, the below, including but not limited to powers provided in the articles exercised by the general manager. So conduct the day-to-day management of school co, execute and terminate all contractual commercial contracts on behalf of school co, C, to represent school co in all business matters required or necessary and before all authorities, D, to conduct or appoint any other managers, to conduct financial and banking matters, 1 operate open, operate and close bank accounts, 2 withdraw, 3 give any securities as may be required by the banks. So again, almost any banking function one can possibly imagine is reserved to to holdco, that's to say Avalon Global. And then 4 at page 71, in general undertake any financial or non-financial transaction. And then 6, halfway down the page, to demand, sue for, enforce payment of, receive and give effectual receipts and discharges for all monies, securities for debts, goods, personal estates, etc. And then over page 72, and this is picking up on the point that a shareholder, even as a matter of general company law, has no power to do anything themselves. So board authority, 6.1, the business shall be managed and all powers of school co shall be exercised under the direction of the board, and except as otherwise expressly set forth herein, the board shall have the exclusive right, power and authority to cause school co to do or cause to be done all acts and actions. Well, that's there as a matter of contract, but we would say that's entirely orthodox as a matter of any company law. You can't have the board running the company and then some shareholder turning up and taking decisions which are in conflict, inconsistent with decisions taken by the board as the authorised representative of the company for the purposes of managing the company. That, we say, is what the board does. And then finally, composition of the board, 7 at the bottom of page 72, turning on to page 73, holdco solely should be entitled to appoint all members of the board. The board will initially comprise 3 directors, so Mr. Kumar, Shubika Sharma, Mr. Kumar Sharma, Miss Shubika Sharma, who is his daughter, and Miss Arundhati Vijay Shetty, so another director. So 3 directors, all essentially appointed by the claimants. And it's Holdco, it's Avalon Global, which shall nominate the members of the board of directors of Schoolco. And then one sees at clause 11 at page 76 the roles and responsibilities of the sponsor. So the sponsor confirms that he has secured the official approval of the Ministry of Education in Ajman, and he has to obtain an education permit from the Ministry of Education. And then 11.3, use his best endeavours to procure on a timely basis all of the utility collections, including electricity, water, sewerage, gas and telecommunications. 11.4 has to assist the school in procuring labour quotas and visas.
Sorry to pause. Existing building, this is owned by Sheikh Khaled, or?
There is one building that was existing, which was in very poor state of repair. He had to bring that up into a good state of repair. He had to acquire 2 other plots, one of which he did in fact acquire, the other which he didn't. And he was supposed to build a second building on the second plot, but he failed to build the second building on the second plot. So
you cannot consider as a contribution from his side as a shares?
It's not a contribution for his shares. It's an entitlement. He's required to do it under the shareholder agreement. It's not certainly not positive. It's not proposed in the agreement as being the consideration or the contribution that he's making for his shares. Although I suppose, as a matter of analysis, it could be your lordship could see it as that. But that's not the way it's presented. He is entitled to a lease, and in the lease makes provision in respect of his acquisition of other sites and his buildings. So one might say that actually it's a consideration of the rent, the very generous rent that he's paid under the lease.
For the existing building, plus, I can say, annual fee as he's a sleeping partner or a sponsor.
Well, exactly. To be fair to Sheikh Khaled, he's not a sleeping partner in the sense that he is required to go and get various approvals from the ministries. And one sees all of the approvals and permits.
You want to say he has an obligation?
He does have an obligation, and which he has. Well, I should say he is not discharged in all cases. And we say that some of the actions he's undertaken, in terms of making false statements about the school, are inconsistent with the obligations that he has. First of all, to promote the school to public authorities. Secondly, his obligation of good faith. But thirdly, his obligation to obtain the necessary consents. If you're required contractually to obtain consents from various public authorities, and at the very same time you're going around bad-mouthing or telling, making false statements about a school, for example, in terms of welfare issues in respect of children, we say that's inconsistent with the obligations that he has in the shareholders' agreement to obtain the relevant public authorities. And one sees here a fairly good summary of the sort of things that he's required to do. So, for example, 11.4, he's required to assist the school in procuring labour quotas and the requisite visas for expatriates. Now, one of the odd things that he's done is he's gathered information on 6 employees, and then he's made a complaint to the police about the employment or the work of those 6 individuals, and claimed that it wasn't consistent with the visa requirements. Well, how does one do that, we say, consistently with an obligation to obtain the requisite visas for expatriates? As I understand, as we're instructed, he knew full well, he entirely understood that these 6 individuals were working on a consultancy basis. And if that hadn't been the case, if they had needed labour quotas and requisite visas for expatriates, then it would have been his obligation to assist in getting those visas. 11.5 is also important. The sponsor will use his best endeavours to promote the school among the community in Ajman and the neighbouring emirates. Well, we say much of what he's done in terms of these denunciations to public authorities in Ajman is far from promoting the school amongst the community in Ajman. One sees here too, 11.6, the lease agreement 11.7, the sponsor shall, having acquired the adjacent plot, will lease the same to the school. So that the lease obligations are also obligations under this shareholder agreement. And then 11.8, the sponsor shall ensure completion of the construction of building on the adjacent plot. So again, an obligation here as a matter of contract to construct the building for a total capacity of 2,000, with the cost of the construction being solely paid by the sponsor, by the sheikh. Yes, those might wish to make the point, which I may not have made sufficiently clearly, that he receives the very generous rent that one sees in the lease, and that's paid quarterly in advance. But the land and buildings in his personal name are not in the school's name, so it wasn't a contribution to the school. Well, I mean, I suppose the answer to that would be that the use of the property is something that he makes available. It doesn't make the property itself, it doesn't transfer the property to the school. He owns the buildings, he allows the school to use them for a long term, and he receives a very generous rent payment, in addition to the share of revenues, which he also receives, which one sees provisionally in the agreement. And that's, again, a very generous provision. That's all I think. I just may perhaps need to... Yes, again, in terms of the governing law, this is at page 87, one sees the law of the DIFC, and one sees dispute resolution in the exclusive jurisdiction of the DIFC courts. That's the contractual background that the court needs to understand in order to appreciate quite how serious the breaches of contract are. The school opened, your Lordship will have seen the affidavit, in 2015. It made losses in its first 2 years of business because inevitably it was opening as a small school and didn't have as many pupils as it would have needed to break even. And it made 8 million dirham of losses. But it has grown in numbers, and it is in a position now that if it were not for the problems that are being caused by Sheikh Khaled, it would have 700 students starting in September 2018. That is the success, if you like, of this school, and that is the success that will be jeopardised, that will be put at risk if this campaign is continued. The constraints that have existed in terms of the school, we say, and your Lordship will have seen this in the affidavit of Mr. Sharma, are entirely the Sheikh's responsibilities. So the delay in providing the utilities, the failure that I just mentioned to obtain the third plot, the failure to construct the second building. Now, my Lord, I don't want to throw those issues into the court today. I don't think we need to. Those aren't matters which require urgent injunctions. They don't require this court to urgently order him to get on with his obligations in terms of plots and buildings. The obligations that we're looking at are matters which are causing damage now to the school and to the business, and for which we need urgent injunctive relief. Now, the first of these breaches is the encashing of the cheque. We say that I should say that the loan from the Ajman Bank was required specifically by the sheikh, by the sponsor, in order to build the second building. And it was the Ajman Bank that required the rental stream payable under the lease to be the security for that facility provided by the Ajman Bank. As it happened, the company moved its banking from Emirates NBD to First Gulf Bank. So Mr. Sharma had to issue new cheques to replace the old Emirates NBD cheques. And everyone knew that the old cheques were being replaced, and one gets that from page 156 in the bundle. I'll just take your Lordship quickly to that.
156?
Yes, page 156.
this letter addressed to...
This is a notice served by Avalon Heights to the Ajman Bank, and if one picks up halfway through this letter, we were then dealing with Emirates NBD, and checks were from Emirates NBD. Now our account is with First Gulf Bank, and for this season we're submitting checks for 30 million from FGB, kindly obliged by replacing them. So the instruction from the school company to the bank was to replace the checks. Efforts have been made to recover those checks, but in fact it was Sheikh Khaled who had recovered those checks. And he proceeded then to cash both the Emirates NBD check and the First Gulf Bank check for the very same date. The Gulf Bank check was paid. He was entitled to his rent instalment for the rent check. What he was not entitled to was to cash both the First Gulf Bank check and the Emirates NBD check. Because there was no money, or insufficient money in the Emirates NBD account, that check, which we refer to as the check, was dishonoured. And having caused that check to be dishonoured, the Sheikh then made a malicious report of that dishonouring of the check. And it's that which has resulted in a travel ban for Mr. Sharma. And it's that which means Mr. Sharma cannot be on the ground. He is stuck in Mumbai when there's great crisis in terms of the administration and management of the school. He is in Mumbai. He cannot be with his school, with his staff, in order to protect them. And we say that is a clear breach of Article 11.4 of the SAEED agreement. That's the 11.4, the good faith requirement. This is not acting in good faith. Sheikh Khaled knew full well that the Emirates NBD check had been replaced. And not only did he cause that check to be dishonoured, but he also took a further step of maliciously reporting the dishonouring of that check. And it's also a breach, we say, of clause 11.5 of the shareholders agreement, 11.5, which is the provision that requires the best endeavours to promote the school. How can you possibly say that you are trying to promote the school when you are reporting Mr. Sharma, the school, for the company, I should say, Avalon Heights, for dishonouring, causing a check to be dishonoured? And we say it's vindictive. We say he knew full well that the check had been replaced. And indeed, the security had been provided by the company to enable the Sheikh to discharge his own obligation. It was his obligation to build the further building. The fact that he requires the rental checks as his security, and they were provided in our submission, makes it an even more egregious breach of the relevant contractual arrangement. That's the first breach. The second breach is the intimidation of staff. Last Monday, so only a week ago, on the 16th of April, the Sheikh took the files of 6 members of staff who he knew to be on contracts. He then made a criminal complaint in respect of those staff. All 6 were detained by the Ajman police. 2 are still, as I understand that, are still in detention. That's Monday. The following day, on Tuesday, the 17th of April, he sent 6 men to the school gates. Members of staff were interrogated in front of parents, in front of pupils. 2 days later, last Thursday, on the 19th of April, late in the evening, he appeared at the school and started to interrogate security staff about the school as to what they were doing there. And he instructed them to inform him and his staff as to who was entering and leaving the site. Now, it's hard to imagine more obvious interference in the management of the company, and it's hard, we say, to imagine more obvious breaches of the obligations not to get involved and the obligations not to interfere as a shareholder. And one looks at...
And who's running the school?
Well, that's
from his side.
From our side, it's Avalon Heights, it's the company. Mr. Sharma is in Mumbai, but he, as the general manager, has delegated his powers as general manager to Ms. Shetty. She's on the ground. She may have been. Yes. Well, and there is a principal. There's a headmaster, head teacher, headmistress, who, as I understand
But still not kicked out from the school.
No, she hasn't yet been kicked out of the school. Miss Shetty, who is the third of the directors. So none of the directors on the side.
She's got paying commission. She does not do it.
She, as I understand it, is subject to a bail condition in Ajman that she may not attend the school site. The implication of that is
She's one of the 6 employees.
She's one of the 6. She is one of the 6. So, so again, it's very much at the moment down to the teaching staff, the head teacher, to run the school, and they are acting, I should say, under a climate of fear. This is a situation where a powerful man, a man seen by them as powerful in Ajman, is doing his best to close down this business, to close the school, to drive away the staff, in circumstances where he has promised in no circumstances to interfere in the management of this business. And that's clause 6.2 of the side agreement, it's clause 5.2 of the shareholder agreement. A man who has promised to act in good faith. A man who has promised to use his best endeavours to promote the school in Ajman. And what will happen if this continues, if the intimidation continues, is that staff will leave and the school will fail. Now, the Sheikh might believe that he could step in at this stage and appoint another staff, but we say that simply cannot and will not happen. This isn't just a hotel business. This is a business which has required very significant expertise on the part of Mr. Sharma to establish, to develop, to the 700 or so students that will be attending in September. And it could all be destroyed in a very short period of time. The third breach that we identify is the making of allegations to third parties. And we say, again, these are entirely false and they are intended to damage the school and its business. So allegations, soliciting allegations of neglect and indiscipline, allegations being made of indecent assault, very serious allegations in any school. And what is implied, when one makes those sort of casual allegations, what is implied is that one has reasonable grounds for believing such allegations to be true. If I make allegations about a colleague in legal practice in any jurisdiction, that would be wholly irresponsible unless I had grounds for making those allegations. And it's implicit in my making of those allegations that I have grounds for making those allegations. It's implicit that I've investigated them. It's implicit that I have some evidence, some reason for believing them to be true. It's implicit that I've considered and weighed and tested and probed those allegations. None of those, in this case, are true. Furthermore, in dealing with the police, he has asserted that he is the owner of the school, the beneficiary of the shares. Now, as a matter of trust law, if I'm a trustee, if I hold shares on your behalf, and I deny my trusteeship, I say, no, I'm not a trustee, I own these shares. That is in itself, the denial of trusteeship is in itself a breach of trust. So it's a breach of trust, it's an implied representation that is false, it is a breach of the express undertaking of good faith towards the school and towards the minority shareholder. And also it may be a tort in DIC law, a tort of the unlawful interference with contracts, because the school, the operating company, Avalon Heights, has contractual relations as a private school with the parents, and to the extent that the Sheikh is seeking to interfere in that contractual relationship between the school and the parents, that, we say, may be an economic tort under Article 34 of the Law of Obligations. And nearly finally, in terms of breaches, one has the freezing of the finances of Avalon Heights by the revocation of the power of attorney. Your Lordship has seen all of the obligations, the express contractual obligations to provide that power of attorney. So clause 2.1 of the, 21 of the collaboration agreement, clause 2.4 of the side agreement, and clause 11.12 of the shareholder agreement. The power of attorney was executed. You have it, my lord, in the bundle at page 27.
Quality bundle?
No, the main bundle, the hearing bundle. So page 27. And that was executed pursuant to the collaboration agreement, which we've seen. And then if one turns on to page 32, you see what Sheikh Khaled has done recently. If your Lordship wants it in the Arabic, it's at page 31.
Earlier,
اختار عدلي
speak Arabic then.
شوي. So you see there the mukhtir, the notifier, and the mukhatar alayhi, the notified.
Okay, I think let's make it in English better.
Yes, the notifying party and the notified party. I think my English is slightly better than my Arabic. And we say that what's being done here is that the Sheikh is lobbing a grenade, in military terms, into the business of this company. This is intended for the very reason your Lordship identified. Because of the nervousness of banks, it's intended to cause maximum damage by freezing the accounts of Avalon Heights. The result has been that First Gulf Bank has refused to act on any banking instructions, even though we say the power of attorney should not be required for banking. Why? Because there's a general manager. There's a memorandum association that allows the general manager and the delegates of the general manager to conduct the banking business of the company. Not only that, but there's actually contractual provisions by which the majority shareholder expressly promises not to get involved in any circumstances in the management of the company, including the financial management of the company. So we say this is a breach of Article 2.4, which requires the power of attorney. It's a breach of Clause 11.4 of the side agreement, which requires good faith. It's an interference with the financial management of the company, breach of Clause 6.2 of the side agreement. It's a breach of Clause 5.2 of the shareholder agreement. And it's especially a breach of Clause 5.5 of the shareholder agreement, which deals specifically with banking. It is a breach of trust, because again one sees that assertions of his rights as a majority shareholder, as the beneficial owner, and we say it is a willful breach of trust. He knows that he should not be doing what he is doing. And lastly, my Lord, it is again, in terms of the working capital, there are two accounts. There's firstly the First Gulf Bank, the FGB account. There's also the facility, the working capital facility with Asil. That is a facility for 4.5 million dirham, which allows the school, as a matter in terms of its cash flow, to employ staff and to pay for equipment that it requires as a school. What does Sheikh Khaled do? Well, he, on the 1st of March, presents a letter at the Asil. That is at page 35. So if I could ask your Lordship to turn on a few pages to page 35.
Yeah, I saw that.
Sorry, and we have the English over page at page 36. And what does he say in the letter? In my capacity as owner of the plot and buildings, issued by the Department of Education and Development, in my capacity as partner in the school with a shareholding of 51%, so he's essentially alleging that he is the beneficial owner of the shares. He's alleging that gives him some authority, neither of which we say are true. Hereby advised not to grant any credit facilities, loans or overdrafts. Well, is it possible to posit a more obvious, grievous infringement of his promise not to be involved in the financial management of this company? Should you grant any facilities, I shall assume no moral or material liability. Well, it's extraordinary. He has no liability. All of the security for this facility are provided by Mr. Sharma. I should say, I mentioned that it's used for salaries. There are 92 staff salaries that draw on the Asil facility. And there's 600,000 dirham needed to be paid this month. Or they will leave. But that is what employees do. If they're not paid, they will leave. And where does that leave a school with its management essentially prevented from managing, its finances frozen, and its staff unable to attend because they hadn't been paid. Now, I mentioned that it's extraordinary that Sheikh Khaled is saying, well, if you allow any transactions to occur, I won't be responsible. When one actually looks at who is providing the security for the Asil account, and if one goes to page 150 in the bundle, well, if one starts at page 147, my lord, one has there the facility letter. So this is setting out the terms of the 4.5 million dirham facility, signed by Mr. Sharma on behalf of, and also on behalf of Asil Finance, so on the 27th of March 2017. And then if one goes on to page 150, so then you see various Islamic finance facilities, Murabaha, in page 149. And then page 150, the security documents. So number one, first degree mortgage on the property located at plot number 327 Al-Hibia, 3rd, Dubai, in favour of Asil Finance. That, I should say, as I understand it, is Mr. Sharma's own villa. Irrevocable personal guarantees from Mr. Sharma and Ms. Shetty, covering overall facility amounts. And then going down, 4 receivables, 5 an undated cheque, 8 assignment of takaful life insurance policy of Mr. Sharma. Again, what one doesn't see here is any security for the working capital being provided by Sheikh Khaled. But nor indeed would one expect to see any security being provided by Sheikh Khaled, because there's no reason why he should. He's not contractually obliged to provide security for the working capital requirements of the company. So for him then to say in this letter, in seeking to spook Asil, for him to say that he will assume no liability, there's no basis on which he possibly could have any liability. He's not the company. He's a shareholder. Shareholders aren't liable for their company unless they've offered any guarantee, unless they've offered any security, which he hasn't done, and which he isn't obliged to do, to be fair. And finally, in this letter, the 1st of March 2018, he makes an allegation of fraud. So we need to go back to page 35 just to see what it is he's alleging. I request you not to approve my signature on any letter executed in English or Arabic, as the director of the school may have obtained the same by means of fraud or deceit.
Sorry, you're reading from the...
Sorry, I'm reading I'm reading from the English of page 36.
Okay, remind me the page.
Sorry, page 36, my lord, or 35 if you're reading in the Arabic.
Okay. Yeah, go ahead. Which paragraph?
So the paragraph beginning, furthermore, I request you
Yeah.
not to approve my signature on any letter executed in English or Arabic, as the director of the school, so that's, I think, Mr. Sharma, Ms. Shetty, may have obtained the same by means of fraud or deceit, by inserting it among the papers I sign in order to operate the school affairs before governmental authorities, such as labour passports and other departments. We do not understand that allegation. The idea that somehow the Sheikh was tricked into signing something that allows us to operate the school before the government authorities. I mean, for a start, it's entirely clear that whilst he is to obtain relevant approvals, it is for the Avalon Global and Mr. Sharma and the directors to operate the school. That's the whole point of much of the side agreement and much of the shareholders.
The agreement between Asil Finance, that's signed between the school, which is represented by Mr. Sharma, and the Asil company of Asil Finance. There's nothing related to Sheikh Khaled or his signature.
No, exactly. A good point, my lord, and one I should have spotted. So again, my lord, in terms of breaches, we say breach of trust breach of the reservation of exclusive powers, breach of the undertaking not to interfere in the management of the company, breach of the undertaking of good faith, and a breach of the undertaking to use best endeavours to promote the school. So quite a catalogue, we would say, of breaches of the contractual provisions set out in the side agreement and in the shareholder agreement. So, my Lord, in very brief conclusion, this school needs the protection of this court, or its business could be destroyed, and we say will be destroyed in a matter of days. In terms of the balance of convenience, if there is an order made that will be effective in preventing the continuation of this campaign for just a few days, there will be no significant prejudice to Sheikh Khaled. There's no risk to him, there's nothing that he will lose by being told to desist for a matter of days. There's no significant prejudice. Conversely, if no order is made, then this school and its business that has been built up and developed over 4 years could be destroyed, and that will damage, we would say, not only the prospects of hundreds of children who attend the school, but also education in this emirate and indeed in the wider UAE. The damages would not compensate the claimants. It's impossible to value the opportunity of a school, not only to the children who attend that school, but also to Avalon Global. The balance sheet, if you like, in terms of the assets now of the school is not a good valuation. We say where you have a school that is being developed and the income is growing, to seek to value it on the basis of, well, this is its current cash flow or this is the current assets, is entirely unrealistic. It becomes impossible to work out what the value of this business is in true terms. The value, we say, would be on an income basis would be far higher than the asset valuation that emerges from the balance sheet. And not only is it the company, but the foreign investors seek the protection of the DIFC law and the DIFC courts. Those foreign investors have been persuaded the local sponsor to submit to the jurisdiction of the DIFC court. And it's this court which we say should hold the ring until the return date. Lord, that's all I have to say.
Okay, thank you. I think it's clear for me. Let's go back to your draft order.
Lord, yes. That's behind
Yeah, tab 3.
tab 3.
The penal notice is fine. Already you attacked the undertaking
Yes.
and already filed a claim for,
We have already taken, yes.
except you don't save it yet.
We will, yes, there is an issue that's certainly. I understand that the intention is to serve, and I'll be corrected, is to serve any order the court is willing to make through, first of all, through the Dubai courts, and then
From Dubai court to Ajman
to
court.
Ajman. There's an issue about whether we should have substitute services served by email, but our understanding is that under the RDC,
Mr. Robert, let's deal with your order, the draft order,
yes.
and for the claim for, I think your colleague they
Well, I
will
think
taken care of.
we're comfortable that we can serve by email under the existing
So,
RDC, so I don't need to struggle with it.
Let's make it short. First of all, I grant the application, but need to review the draft order. I need a soft copy to send it to the registry, if possible today.
It is sent.
You have it? Just I want to double check with the retain date. So number 2 of the order.
Yes.
This one will find from my side or from the registry, which the proper retain date.
Right, so the registry,
For-
we can liaise with the registry about your return date. And then
And who's going to hear the case or application on return date? Me or other judge? It depends to the...
Well, we would have a preference for your lordship, because your lordship has read the papers. And heard.
Thank you for that, but it depends to the registry procedure here. Just to clarify of electric and water authority, so it's not clear for me.
Sorry.
The point 6.
Point 6, until the return date. That's required under the...
A and B.
Okay, the system action is disconnected. Well, your lordship sees the problem, which is that he has in the past failed to make payments, and that has resulted in the school being disconnected. Okay. I'll just take instruction. Well, we're content to delete A if it's causing concern.
Okay.
So we deleted 6A.
And will 6 be remaining?
Our preference would be for B to remain.
And you refer to the okay. In regard the service or serving disorder, in which way you want it? By email or through Dubai court or through Ajman court?
So I'll take instruction. My lord, the proposal is that it should be served by email. Clearly, it's very urgent. We want to make sure that he's aware of this as soon as possible.
As alternative.
As an alternative.
Okay.
Just, my lord's. My lord, yes. If your lordship were able to make express provision that we can serve by email as a under RDC.
Yeah, I'm aware of the article.
Yes,
so please
I'm
provide me with the proper email you want to serve this order.
It's on
At least I want to add it.
it's on the claim form, but we will send it to the registry.
So then send me a revised
We will
draft
send a
order.
revised order with all of the, having liaised with the registry and dealt with those wrinkles, we will send it to both to your lordship and to the registry.
And I don't know how you're going to enforce point 7 of the same order in regard the attorney, power of attorney.
Well, he'll either do it or he won't. But we say the court is entitled under the court law to require someone to do something in accordance with their obligations. And we say there's a contractual obligation to exercise the power.
Yeah, I got your point, but according to the notice, it's already end. Already he cancelled the power of attorney.
Okay, well, we've asked him to sign the power of attorney in accordance with his obligations under the signed agreement and the share.
This is my understanding, unless if you want to double check on this one. Because
we prefer to keep that in, keep 7.
okay, fine. So far, nothing. If I have any points, definitely I will contact you through registry. And if you send it today, I'm going to release the order today.
That's very helpful.
Or earlier tomorrow morning.
We're very grateful.
Thank you.
Omar.